Thank you, Peter, and thank you all for coming. This is part of a larger project I'm doing for a book on the Irish Supreme Court, which is basically looking at the history of the court over its 93 years to date and comparing its progress, if you like, with that of other Supreme Courts in other common law jurisdictions. I'm very nervous about the book, as I am about this talk, because first of all, I'm dealing with a jurisdiction which is relatively unfamiliar to me, as it is to most academic lawyers in this part of the world, I have to say. Very few of us use Irish law in our teaching or in our research. But I'm also nervous because I need to, in the book anyway, relate what I'm saying to the political and social life of Ireland through that period, and that's not a specialism of my own either. But even for today's talk, I'm nervous because the title suggests that I have criteria for assessing whether the Supreme Court has achieved anything or not. And I have got some criteria, but there's remarkably little literature that I could find on what criteria are appropriate to judging the performance of a Supreme Court in any national context. The ones that I'm going to be using off and on during this talk are, firstly, the need for the top court to be independent in every way, and the judges on the courts to be independent and to be incorruptible and to have integrity. Secondly, I think we should judge a court of this kind on its support for the separation of powers doctrine, in that they're there primarily, or at least substantially, to ensure that the government and the parliament do not each exceed their powers. Thirdly, I think one could naturally expect a top court to speak out in favour of certain fundamental principles that are in some way associated to justice. So the principle of equality, for example, or fairness, or the principle of transparency. So I'm going to be talking a little bit about those. And lastly, the four criteria that I've drawn up for myself is the one of efficiency. You would expect the court to give judgments pretty quickly and clearly and accessibly. So this is more than just an examination of whether the Supreme Court of Ireland has been judicially active. There's quite a bit of literature on judicial activism. And some years ago I edited a book which included a chapter by William Binchy, the then Regius Professor of law at Trinity, and he did do a very good chapter on judicial activism in the Supreme Court. This book that I'm doing goes a bit wider than that. Strangely, there's hardly anything written on the Supreme Court as an institution. There's William Binchy's fine article. There's an account, it seems strange to be citing McGill from 1985, but the magazine McGill had a very long article in that year by Colin Tabine. Was he the editor of McGill at that time? I think he might have been. In which he analysed the character of the judges in post at that time and previously. He covers all, I think, all the judges sitting at that time and many of the ones previously. He called the court, but this might just have been hype for the magazine, he called it the single institution which over the past 20 years has had the profoundest effect on Irish society. I do think that's a bit of an overstatement. Maybe not so much in 1985, when looking back, the previous 20 years had been quite important from the Supreme Court's point of view. But if we stand now and look back for the 93 years that the court's been in existence, I don't think we can say it's been the single most important institution on Irish society. There was a little book by David Gwynne Morgan, Professor of Law in Cork, back in 2001, called A Judgment Too Far, which basically argues that at that date the court was overreaching itself. It was impinging too much on governmental and parliamentary powers. And the most recent contribution to the literature is a very good book by Ruan McCormick, the Irish Times journalist, that came out just last year, which is written in a journalistic style but is very well researched and is very gripping, and I tell you will be 100 times more readable than the book that I eventually produced, and indeed I do. So the origins of the court are, and this is an outline of what I'm going to cover or try to cover. I'll probably not get through it all, but I'll get through most of it hopefully. The origins of the court lie in the fact that prior to the Irish Free State being set up, the Supreme Court for Ireland was the Appellate Committee of the House of Lords, set up by statute. It had existed before then, but it was set up by statute in 1876. And interestingly, 7 of the 22 people, all men of course, who were appointed to be law lords in that committee from 1876 to 1921 were Irish. They were Irish barristers. But with the creation of the Irish Free State, the Supreme Court, the top court for what was then the 26 counties, became first of all the Court of Appeal of Southern Ireland for the year or so that Southern Ireland existed, with the possibility of an appeal to the Judicial Committee of the Privy Council, of which more anon. There had also been from 1919 Dáil-Éireann courts, including a Supreme Dáil-Éireann Court, which wasn't officially abolished until 1922. There was a slight overlap then between it and the Court of Appeal of Southern Ireland. There was also a High Court of Ireland set up that supposedly heard appeals from the Court of Appeal of Northern Ireland and the Court of Appeal of Southern Ireland, and there could be appeals from it to the House of Lords. You probably know more about that than I do, David. I haven't been able to track down any decisions of the High Court of Ireland, but I gather there were some.
I'm not
you don't, okay, well I think there were 1 or 2, but the court disappeared pretty quickly. So it wasn't until the Courts of Justice Act was passed in 1924 that the promise made in the Irish Free State Constitution to create a new legal system was fulfilled, and it came after a committee report chaired by the outgoing Lord Chancellor of Ireland, Lord Glenavy, Sir James Campbell as he was. And that so-called Judiciary Committee did all of its work in about 8 or 10 weeks and produced a very slim document, 26 pages I think it was, which laid out the blueprint for the court system for Ireland, and that blueprint remains in place today by and large. The Attorney General at the time was Hugh Kennedy, and he was a member of the Judiciary Committee, and he was appointed as the first Chief Justice of the Supreme Court in 1924, and 2 other judges were appointed to sit with him. So this is a sort of view, an overview of how the court has developed in size since 1924. You have the Chief Justice and the President of the High Court of Ireland, who ex officio is entitled and was then entitled to sit as a member of the Supreme Court, plus 2 ordinary judges. Then in 1936, just before the new constitution was put in place, the number of ordinary judges was increased to 4. The new constitution provided for a new Supreme Court, but that didn't actually come to fruition until 1961, because the requisite legislation wasn't passed until then. But as it turned out, the new Supreme Court turned out to be almost identical to the old Supreme Court. So although the former court is sometimes called the old court, there isn't, to all intents and purposes, much of a difference between them in terms of jurisdiction or powers. So it wasn't until 1975 that a further change was made to the composition of the court, and that was because the Law Reform Commission was set up at that time, and provision was made for the fact that if a judge of the current Supreme Court was appointed as a member of the Law Reform Commission, then another person would be appointed to sit on the Supreme Court to replace that person, because it was reckoned that he or she could not both be an active member of the Law Reform Commission and a member of the Supreme Court. But it wasn't really until 1996, 60 years after the 4-judge limit was put in place, that 3 additional judges were appointed. That was largely because at that time the plan was that the work of the Court of Criminal Appeal, which had also been set up back in 1924, should be moved into the Supreme Court. And that additional workload, caseload, it was felt, required the appointment of additional judges. As it happened, the transfer of the Court of Criminal Appeals work to the Supreme Court never took place. Meanwhile, however, the number of appeals going to the Supreme Court rose and rose, so much so that in 2013 the government felt it necessary to add another 2 judges to the Supreme Court in an attempt to deal with the backload of cases. But that was a bit like, putting your thumb in the dike, because the number of appeals continued to rise, and the government then decided that the time had come to slim down the Supreme Court in terms of its workload, reduce its jurisdiction. And that was done by creating the Court of Appeal of Ireland, which was put in place after a referendum in 2013. It was set up at the end of 2014. And that took over the work of the existing Court of Criminal Appeal, Criminal Court of Appeal, took over that work and took on many of the civil appeals that would have gone from the High Court to the Supreme Court. So the overall number of appeals remaining with the Supreme Court reduced dramatically, though it's still dealing with some of the legacy cases, those that were already in train at the time of that transfer. With that creation of the Court of Appeal, the President of it became ex officio a member of the Supreme Court as well. So the maximum number of judges that there can be on the Supreme Court is 13, if one of them at the time happens to be a member of the Law Reform Commission. That's not the case at the present. So there only are 12 potential judges at the present, 2 of whom are ex officio. So in effect, the Chief Justice and the 9 ordinary judges are the ones who sit most frequently in the court. They sit in benches of 3 or more. If they're dealing with constitutional cases, they have to sit at the bench of 5. Occasionally they do sit at a bench of 7 or more, but that's very rare. Up till now, if we don't include the ex officio judges who are never separately appointed as ordinary judges or as the Chief Justice, there have been 54 individuals who have been appointed to the Supreme Court, 11 of whom were Chief Justices. 6 of them are female. The first female to be appointed was Susan Denham in 1992, and she is currently the Chief Justice of the Supreme Court. And ever since 1924, when Gerald Fitzgibbon was one of the 3 judges appointed to the original court, who was a member of the Church of Ireland, his forefathers having left the Catholic Church to join the Church of Ireland, there is a convention, it's not in law, that at least one member of the Supreme Court should be from a Protestant background. And it just so happens that Susan Denham, the Chief Justice, is that Protestant on the Supreme Court at the moment. That's her on the left. Top right is Sean Ryan, who's the President of the Court of Appeal, and bottom right is Peter Kelly, who's the President of the High Court. They are the 3 most senior judges in Ireland. The strict rules of precedence telling us that those are the 3 senior people. That's a sketch of the jurisdiction of the Supreme Court as it was prior to the creation of the Court of Appeal. What you now need to do my graphic skills didn't allow me to do this, but what you now need to do is take out the Court of Criminal Appeal, put in the Court of Appeal, but have it running across both the civil cases and the criminal cases columns. And that had the effect of taking on board a lot of the High Court appeals as well as the criminal appeals from the normal Central Criminal Court, which is what we call the High Court when it's dealing with criminal cases, and also the Special Criminal Court, of which more anon. Let's look at the court's independence. Throughout the life of the court, the accusation has been that people are appointed to the court because of their political background. People have tried to find evidence that judges appointed because of their political background have used their political views to determine the outcome of cases. As yet, I don't know anybody who has produced hard evidence to show that, for example, somebody who was a supporter of Fianna Fáil and was appointed to the Supreme Court applied a Fianna Fáil solution, if you like, to particular cases that were coming before him or her. There appears to be no evidence of that. But it is in itself undesirable, we would think, that people should be appointed to the court just because of their political background. In 1971, an American called Bartholomew conducted a study whereby he interviewed all the sitting and retired Supreme Court and High Court judges in Ireland. And he found that 65% of them admitted to being Fianna Fáil supporters when they were appointed to the court, and 18% admitted to being Fine Gael supporters. Bear in mind that Fianna Fáil had been in office for most of the previous 30 odd years or so it was natural that the percentage of Fianna Fáil supporters should be higher. But only 12% of all the judges interviewed said that they had no political affiliation. And Bartholomew concluded that almost all appointments had been based on political considerations. Only 41% of those people appointed thought that they had been appointed because of their professional expertise in the law as opposed to their political views. Things came to a head a bit as regards political appointments in the mid-1990s when Chief Justice Tom Findlay was due to retire, and the most qualified person to replace him was Liam Hamilton, who had been President of the High Court since 1985. But he had just spent 3 years chairing the Beef Tribunal. And the feeling was that in his report he had been unduly lenient towards Fianna Fáil ministers who had been complicit in various activities to do with the beef industry. So the report wasn't as condemnatory as the Labour Party, which was in coalition with Fianna Fáil at the time, had expected. So the Labour Party did not want Liam Hamilton to be appointed to the Supreme Court. On top of that, if he had been appointed, the presidency of the High Court would have become vacant because that's the post he was occupying. And the favourite to be given that post was Harry Wheelahan, the Attorney General, who had been central to the X case in 1992 involving the teenage girl who was being injuncted by the Attorney General from leaving Ireland to go to England to get an abortion. So he wasn't a popular character in Labour's eyes. So there was a bit of a standoff over all of that. In the end, Fianna Fáil got its way, and Liam Hamilton was appointed to be the Chief Justice, and Harry Wheelahan was appointed to be the President of the High Court. But as you probably know, Harry Wheelahan stayed in office just for 2 days because it came to light that he had allegedly, I don't think it was ever proved, he had allegedly delayed the extradition from the south of Ireland to Northern Ireland of Brendan Smith, the alleged paedophile priest, because Wheelahan had said there's never been a case like this before, and that's why it's taking us so long to process it. But it came to light that there had been another case on more or less the same point, which Wheelahan had known about and been involved in, and so his credibility was chopped to pieces. He resigned as the judge. He has apparently tried since then on several occasions to become a judge, but has never been appointed. Anyway, all of that led to the Courts and Court Officers Act of 1995, which created the Judicial Appointments Advisory Board. Now, it operates by advertising vacancies for judicial posts, considering applications, and sending a list of 7 names for each vacancy to the government. Prior to the existence of this board, all appointments were by the government, in particular by the Taoiseach, on the advice of the Minister of Justice and or the Attorney General. So this board was an attempt to introduce a more meritocratic approach to the appointment of judges. But the board itself could not say who they thought should be appointed. They were only able, and were still only able, to give 7 names per vacancy from which the government can choose. But in addition to that, a section of the Act allows the government to bypass the board in situations where they think that there's an obvious candidate who can fill the role. So in particular, if there's a vacancy on the Supreme Court and there's somebody on the High Court, say the President of the High Court, who's been in office for quite some time and has not blotted his or her copybook, the government is at liberty to say to the board, right, we're going to appoint so-and-so from the High Court to the Supreme Court. And that's happened quite a lot. Of the 11 vacancies in the Supreme Court since the year 2000, 10 were filled in that way, so not through the involvement of the JAAB, I'll call it. So having looked at the annual reports of the JAAB, the figures are a bit confusing, because at one point they say that between 1996, when it was created, and 2015, when this report was issued, there were 27 applicants for 14 vacancies on the Supreme Court. And I can't quite work out how the board can say that when it wasn't involved in many of the vacancies that did arise. But anyway, if there were only 27 applicants for a total of 14 vacancies, that tells you a lot about how, either about how unwilling people are to be appointed to the Supreme Court, or how little talent there is out there worthy of being appointed. All of this is in the news again at the moment. But before I just come on to that, a book was published just a year or so ago by Jennifer Carroll McNeil, who had previously done a study in 2005 of the political appointments to the judiciary. She was repeating the Bartholomew study of 1971, and she discovered that whereas previously only 41% of the judges had thought they were appointed because of their legal merit, 60% of the judges that she interviewed, and she interviewed all the Supreme Court and High Court judges, thought that. But 18% still thought that their political connections had had an influence on their appointments. And all of the women appointed thought they had been appointed because they were a woman.
They were the honest ones.
Maybe, that's right. So, given other controversies that have arisen in recent years to do with expenses and salaries of judges, of which I might speak in a moment, the appointment system is under discussion again. One additional reason is that a prominent ordinary judge of the Supreme Court, Adrian Hardiman, died very suddenly at the age of 64 last March, shortly after Antonin Scalia had died. He was a member of the US Supreme Court, and the two of them were quite conservative in their approach to the interpretation of the Constitution and the resolution of social disputes. His death left a vacancy which has still not been filled. The Irish government is consulting on a Judicial Appointments Commission bill which will replace the JAAB, but if created, this Judicial Appointments Commission will still not have the power to appoint judges. It will have the power to recommend 3, not 7, potential appointees, and the power to rank them. And there won't be, well, it remains to be seen because the legislation is still in draft form. There are many lobbying for the removal of the power of the government to bypass the Commission, or as it was, the board. But in the bill as it stands at the moment, there is a section which would allow the government to bypass the Commission system and just elevate, as it's called, elevate existing judges to higher posts. So that's all happening at the moment. It had been expected that the bill would be put before the Oireachtas sooner than now, but it hasn't yet appeared. And in fact, just last week, the Solicitors' Organisation in Ireland, issued its comments on the bill, and there are no doubt lots more comments to come. So we're some way off of getting a new judicial appointments system. A serious blow was struck to the credibility of the Supreme Court in 1999, when Mr. Justice O'Flaherty inappropriately took an action on behalf of a friend, whereby he reminded a circuit court registrar that it was possible to get early release of somebody who had been sent to prison. And that led to the early release of a man called Philip Sheedy, who had been sent to jail for drunk driving. O'Flaherty tried to exonerate himself, but the pressure became too much. A report was issued by Liam Hamilton, the Chief Justice, and O'Flaherty had to resign from the Supreme Court, as did a circuit court judge and the registrar. That was a bad moment for the Irish Supreme Court. Coincidentally, at exactly the same time, a dispute was raging in England over Lord Hoffman, because he was sitting in the Pinochet case, and as most of you in the room will know, the decision of the House of Lords to allow Pinochet to be extradited had to be vacated, had to be annulled, because it came to light that Lord Hoffman, who had sat in the court, was a director of a charity that was part of Amnesty International, and Amnesty International had intervened in the case. Moreover, Lord Hoffman's wife worked for Amnesty International. Now, there were cries for Lord Hoffman to resign from the House of Lords, as it was then, in Britain. He didn't, and it seems that's because he had declared his connection to Amnesty International to the senior law lord at the time, Lord Brian Wilkinson, who had told him that it didn't really matter, nobody would actually believe that Lord Hoffman would allow his connections to Amnesty to influence the way he would decide the case. But of course, it's not about whether it would actually have influenced him, it's about whether people would have thought it would have influenced him. Perception is everything. So Lord Hoffman got away with it and sat on the court until 2009, but O'Flaherty did not, unfortunately. More recently, there have been controversies over salaries and expenses. At the time of the cuts to public pay, in the wake of the 2008 financial crisis in Ireland, many judges refused to voluntarily forego their salary or part of their salary. No particular names came out, but a lot of them didn't do it, and a lot of the judges, led by Mr. Justice Hardyman, argued strongly that if judges were forced to give up some of their pay, it would strike at the independence of the judiciary. So the matter was put to a referendum in 2013 or 2011, was it, I think. 80% of the people, quite naturally, voted in favour of allowing the judges' salaries to be cut, and the Constitution was amended to allow that, and their salaries were cut by approximately 30%. Moreover, judges appointed from the 1st of January 2012 were appointed on a lower scale than serving judges. So at the moment you've got some members of the Supreme Court, you may have seen the Irish Times on Saturday, it had these figures. There are some members of the Supreme Court who get paid €198,000 a year, not bad, but still less than many other judges in comparable courts elsewhere get. But those appointed since the 1st of January 2012 get 10% less than that, €178,000. Arguably the biggest constraint on the effectiveness of the Supreme Court since 1924 has been the constitution of the day, either the Free State Constitution or the 1937 Constitution. That might sound odd, particularly as both constitutions contain sections that confer individual rights. But the consequence of that has been that the Supreme Court has focused on those provisions in the Constitution at the expense of developing the common law. Now, the common law was transferred over to Ireland with partition and remained part of Irish law unless and until the Oireachtas or the judges changed the common law. And there are bits of the common law that have remained unchanged today, since that were transferred in 1921. But the judges have not developed the common law because they've been focused on the Constitution. To my mind, it's comparable to what the judges in Britain have done since the Human Rights Act came into force in 2000. They've neglected the common law on human rights and instead interpreted the Convention rights as conferred by the Human Rights Act. The consequence is that if the Human Rights Act is repealed, the judges in Britain may find that the common law of human rights cannot fill the void that is left by the Human Rights Act. But in Ireland, it's not just that the judges have focused on the constitutional provisions, they have done so in an overwhelmingly conservative manner. With the exception of the period between 1965 and 1975, when there was a florescence of judicial activism, otherwise the court has been very conservative. So right back in 1934, when the Oireachtas passed legislation providing for special tribunals to be set up, whereby people could be charged with a particular offence and could be sentenced to death for that offence, and there could be no appeal against that sentence. That provision was looked at by the Supreme Court in the Ryan and Lennon case, and by 2-1 was held to be constitutional. And that's because the Free State Constitution, while giving the Supreme Court power to declare legislation unconstitutional, went on to qualify that by saying that for the first 8 years of the life of the Free State, the Oireachtas would have power to amend the Constitution, not the people through a referendum. And in 1929, the government secured, through that provision, an amendment to the Constitution extending the 8-year period by a further 8 years. Thereby, if you like, disempowering the Supreme Court and establishing the doctrine of parliamentary sovereignty in a way even that Dicey would not have recognised in England itself. Well, almost, I think. It was a huge endorsement of the concept of parliamentary sovereignty. Meanwhile, at this time, and earlier and later, the Supreme Court in Ireland was trying to distinguish itself from the British courts. If you go back and look at what Hugh Kennedy and others were saying in the early 1920s, their overall goal was to cut the ties with Britain. Moore and Attorney General is the case that decided that appeals that have been preserved by the initial Constitution from the Supreme Court to the Privy Council could no longer take place. Ironically, the Supreme Court itself refused to make that ruling. It was a ruling made by the Privy Council. The Privy Council gave up its right to hear appeals from Ireland, just about at the same time as civil appeals were taken away by Canada from the Privy Council. The major innovation made as far as the Supreme Court is concerned by the 1937 Constitution is that it gave the court the power of anterior review, a priori review, rather than just posterior review. In other words, it gave the President power to ask the Supreme Court to rule in advance of a bill becoming an act that the bill was constitutional or not. That power has been exercised 15 times right up until now. Some cases have resulted in a finding of constitutionality, others have not. But in the Lennon case in 1940, which was again a case about special powers being taken during the emergency, in effect internment, the Supreme Court was asked, before the bill was officially passed, to say whether it would be compliant with the Constitution to intern people, and they said yes, it would. So that's the pendant, if you like, to the earlier Ryan and Lennon case, and it shows that the Supreme Court had not really changed very much in those few years. Now, an assessment was made by another American academic, McWhinney, in 1954, of the performance of the Supreme Court up until that point. And he was really quite negative in his assessment. He compared it naturally to the US Supreme Court, and he reckoned that it came out very badly. He says, "It must be said at the outset that the Irish Supreme Court's work to date has been rather less daring and innovatory than one might have expected, granted the break with the past represented by the Constitution of 1937, and especially the novel character and comprehensive provisions of the Bill of Rights in that Constitution." At the end of his article, ironically, he goes on to complain that the Supreme Court has not done enough to embed Catholicism within Ireland. He's quite explicit about that. He regrets that not enough by that stage had been done to as it were, make the church more a part of the state. Anyway, in the 1960s and 70s there was this fluorescence. So in Ryan, the Supreme Court held that it would be a breach of the personal rights of the citizen to put fluoride in the water. In O'Brien, they ruled that evidence obtained against an accused in breach of his or her constitutional rights would be inadmissible unless there were very exceptional circumstances, which was contrary to the English common law rule. In O'Callaghan, they ruled that a person cannot be denied bail simply because there's a worry that he or she might commit a future offence. That was quite a draconian, quite a startling rule, which was very unpopular for the next 20 odd years or so because governments felt it was a constraint on dealing with offenders. In Byrne in 1972 they ruled that citizens of Ireland can take their own government to court in a way that wasn't at that time possible under tort law in Great Britain. So as Tabine put it in his McGill article, the Byrne case was the equivalent of taking the Union Jack down from the mast in the castle. By saying that the Irish state can be sued by its own citizens, it was re-emphasising the break with the UK. In McGee, famously, the court ruled that the ban on contraceptives was unconstitutional. And in King, in a very impassioned judgment by Mr. Justice Henchy, they ruled that the loitering with intent offence created by the Vagrancy Act was in breach of the Constitution. So a whole set of cases there that really stood up for the personal rights of the individual. Now, David Gwynne Morgan, in his short book, suggests that the reason for that fluorescence was the unpopularity of politicians at the time. I'm not sure there's hard evidence for that. I think it's more likely to be either the mood of the 1960s, the idea that change was in the air, even for judges, possibly the influence of the American Supreme Court, which from the 1950s onwards was becoming much more interventionist in its approach. But the most obvious reason for the fluorescence is the personality of these three men, who were all members of the Supreme Court. Carew O'Doyle was appointed first of all as an ordinary member in 1953, but he became Chief Justice in 1961. He left in 1973 to become the first Irish judge in the European Court of Justice. 2 years after that, of course, he became the President of Ireland. 2 years after that, he resigned because he had had the temerity to refer a government bill on emergency provisions to the Supreme Court for its ruling on whether it was constitutional, and the Minister for Defence said that he was a thundering disgrace to have done that, and O'Daly was so annoyed by that because even though the Minister of Defence apologised, that O'Daly felt he had to resign to preserve the integrity of his office. Anyway, he was a very liberal individual, as was Brian Walsh up to a point, who served on the court for nearly 30 years, and for part of that time he was accompanied by Seamus Henchy, who was more consistently liberal than Brian Walsh. And interestingly, when Colm Tóibín wrote his piece in '85, he finished it by saying that Brian Walsh was the best judge in the country and one of the most significant figures in the history of the Irish state. Regretting, he said, Tóibín said that Walsh had been passed over 3 times for the role of Chief Justice. And that was just a few years before Brian Walsh held that homosexuality in the Republic should be a crime in the Norris case. I don't think Colm Tóibín, who is himself gay of course, would now be lauding Brian Walsh in quite the same terms as he did back in 1985. In more recent times, the court has not covered itself in glory, however, when it comes to the protection of social and economic rights. That's largely due to the influence of Adrian Hardiman, both in his court judgments and in his extrajudicial judgments. In these 2 cases, the Supreme Court refused, in the first of them, to force the government to provide education for a man who was of primary school age, even though the Constitution says that there's a right to primary education. Somebody who was older than 18 but had a mental age younger than 18 was denied primary school education, and the Supreme Court refused to force the government to provide that. And in the TD case, Mr. Justice Kelly of the High Court, he's now the President of the High Court, ruled that the government should provide facilities for young teenagers, a girl in this case, who were very mixed up, and there wasn't a place of safety for them to stay in. And the judge threatened the 3 ministers involved with an injunction if they didn't supply a place. The Supreme Court overturned that decision. And to this day, the Supreme Court is very reluctant to protect social and economic rights. Article 45 of the 37 Constitution contains directives of social policy, but specifically says that they are to be non-justiciable. And the Supreme Court has not found a way around that. In fact, it's very happy to rely upon that as an excuse for not protecting social and economic rights. And the government of the day, of course, today is unwilling to do that. Despite its support for a Bill of Rights for Northern Ireland, it has refused, just a couple of weeks ago, it refused to support a private member's bill incorporating the International Covenant on Social and Economic Rights into Irish law, because it thought that would go against, the power of the government to decide what it thinks best for the country. Right, I'm running short of time, Peter, so I'm going to wrap up very, very quickly. Those are the main cases that went from the Supreme Court to the European Court in Strasbourg. The underlined ones are ones dealing with judicial separation, divorce and abortion, which did not actually even get to the Supreme Court because there wasn't a remedy they could have gone for. So the European Court was able to accept those cases even though the Supreme Court had not looked at them. But in all the other cases, the European Court overruled, well, that's the wrong term, but disagreed with the Supreme Court's decision. With the exception being Lawless, which was the very first judgment ever issued by the European Court of Human Rights. And both the Supreme Court and the European Court held that it was lawful to intern people during the 1950s in Ireland. A bit ironic in that 10 years after that, well, a bit more than 10 years, the Irish government was bringing the UK government to court for interning people in Northern Ireland, and on that occasion, on that occasion the European Court was consistent, at least, in saying that internment in the UK was just as justifiable as it had been in Ireland. If you were to look at the family law decisions, you would conclude, I think, that the Supreme Court has been extremely conservative in the Republic, partly because of the Constitution's provision protecting the family. So, illegitimate children, sperm donors, surrogate mothers, those sorts of people have found it very difficult to get a remedy in the Republic because they don't quite fit in with the constitutional notion of the family. Though in this Ward of Court case, the Supreme Court did permit a withdrawal of treatment from a woman who was in a permanent vegetative state and had been for 23 years. I'm not quite sure how they reconcile their approach to that difficulty with their approach to abortion, which, although in the X case they held that it was unlawful to prevent the girl from going to Britain to get an abortion, they didn't set out in particular terms what conditions had to be satisfied before somebody was entitled to an abortion in Ireland without going to the Republic, to Great Britain. And if you were to look at the criminal law cases, the big blot on the landscape here is the court's consistent support for the Special Criminal Court. On at least 3 occasions, the Supreme Court has upheld the constitutionality of the Special Criminal Court, which can only be set up because the government declares that the ordinary courts are not able to maintain law and order. It's a very subjective provision. It has never been, to my mind, objectively justified, and the Supreme Court has gone along with that, despite even Mary Robinson, who's led the campaign before and after she was president, before she was president and after she ceased to be president, she has lobbied for the abolition of the Special Criminal Court. Far from that, the government has recently extended the jurisdiction of the Special Criminal Court to deal with organised crime. So it doesn't just deal with IRA terrorists or other terrorists, it deals with organised crime as well. A little slide on statistics showing that even with the reforms in 2014, with the setting up of the Court of Appeal, there's a lot of legacy appeals still to be dealt with. In 2 or 3 years' time, we may be in a position where the Supreme Court is hearing only 100 appeals a year or so. If and when they get to that position, they will be more comparable to the UK Supreme Court and the US Supreme Court, and will be able to spend more time on developing longer, length is not necessarily the issue here, but better judgments that are more thought through, that are more comparative. They deal with jurisprudence from other countries. They locate the Irish solution within an international context. That's been missing up to a point to date. But I think we might be on the verge of a new era where the Supreme Court comes into its own as a court that doesn't have a hugely wide jurisdiction or workload. Summing up then, I think the main achievements are these. It has tried to be an Irish court for the Irish nation. It has avoided allowing party politics to influence the decisions by particular judges. It's been good at upholding the separation of powers doctrine. Several women have been appointed, and Susan Denham has done a terrific job, I think, as Chief Justice. She has to retire this year, by the way. And at times, especially in the 60s and 70s, it was creative in the way that it interpreted the Constitution. On the downside, however, its heavy caseload has prevented it from producing really top-notch judgments. Various institutional flaws have have stifled it. So in cases dealing with whether an act is constitutional or not, only one judgment can be issued, and no expression of dissent can be made public in those cases. So that obviously stymies a plurality of views being made public. It has predominantly, apart from the blue period in the 60s and 70s, been conservative in the way that it's interpreted the Constitution, and it hasn't been properly comparative. And unfortunately, Supreme Court judges, along with every other judge in Ireland, I think have lost some respect in the last decade or so, partly due to their reluctance to give up their salaries and their claims for expenses. So I'm really sorry for going on so long, Peter. I misjudged the timing.
No,
but thank you anyway.
Thank you very much. Great. So can we...